Question, Baroness Chakrabarti.
I beg leave to ask the question standing in my name on the order paper.
My Lords, the Government is fully committed to abide by its obligations under the Convention, in line with the Brighton Declaration of 2012, agreed under the UK's chairmanship of the Council of Europe's Committee of Ministers. We will continue to lead efforts to ensure the effective implementation of the Convention by all state parties in accordance with the principle of subsidiarity and the margin of appreciation afforded to them under that declaration.
Well, I welcome the noble Lord, the Minister, to his very well-deserved new role. And I thank him for his answer. But I'm afraid that what Amnesty International has called the Rights Removal Bill, published yesterday, tells a rather different story. Its provisions drastically dilute the positive obligations on the police to protect the public from sexual and violent crimes, and it attempts to break the vital link between our domestic courts and the Court of Human Rights in Strasbourg. My Lords, how can ministers get on aeroplanes to talk about human rights elsewhere in the world whilst promoting such a hatchet job at home?
I thank the House for its welcome, and we have, as the House knows, this afternoon an oral statement when we can go into more detail on some of these questions. But in general terms, if I may at this stage confine myself to general terms, the Government's view is that this bill will strengthen our human rights framework in this country, and in particular, and these are the key words I would like to introduce, by introducing a better balance in the human rights framework. A better balance between the judiciary and the legislature, a better balance between UK judges and Strasbourg, and a better balance between rights and obligations. We stay in the Convention. The rights in the Convention are still there in UK statute, but we seek to rebalance and clarify, in the words of the Act, and thereby restore public confidence in our human rights framework.
My Lords, may I also welcome the noble Lord to his present place? He is very welcome. My Lords, would my noble friend agree that in a parliamentary democracy there is a great deal to be said for leaving to the Supreme Court of this country the ultimate interpretation of the meanings of rights and their application? Because if Parliament happens to disagree with that interpretation, Parliament can reverse or modify it. Whereas if the ultimate arbiter is the European Court, that is not possible. And isn't that a serious democratic deficit?
My Lords, I would respectfully agree with my noble friend.
46 of the European Convention on Human Rights is very clear, and I quote, that the high contracting parties undertake to abide by the final judgment of the court in any case to which they are parties. This is more fundamental than subsidiarity, more fundamental than a margin of appreciation, because now the government plans to make our own courts the final court of appeal. How do the government reconcile this with the clear obligations under Article 46 of the Convention?
My Lords, the United Kingdom remains bound by Article 46 of the Convention, and in the unlikely and relatively rare event, let it be hoped, that the United Kingdom is found to be in breach of the Convention, then there will be a matter of political discussion and settlement in the context of the Committee of Ministers, as has happened from time to time in the past, for example, in relation to prisoner voting. So that situation remains unchanged. What we are doing within this framework is achieving, in the government's view, a better balance in the mechanics of the Convention rather than the fundamental principles.
My noble friend.
My Lords, would the noble Lord the Minister agree that by definition there can be no hierarchy of human rights, and they should be exactly the same, whether it's in Europe, in Britain, or for those who are seeking refuge and asylum in small, leaky boats.
My Lords, the Convention recognises a margin of appreciation and the principle of subsidiarity as to how each of the member states implement their duties under the Convention. There is no hierarchy as such, but there are going to be variations in the way those rights are secured. And one right in particular that this bill redefines and promotes is the right to freedom of speech, which lies at the heart of our democracy.
Noble Lord will be well aware that that the Human Rights Act will forever be linked to the name of David Maxwell Fyfe, who, supported by Winston Churchill, was one of its most principal authors, and is implicit in Lady Chakrabarty's question that we have, over the last years since its passage, being both a leader by example and an influencer in Europe. Is he really satisfied, I'm sorry to say this in welcoming, is he really satisfied to continue to be a member of a government which is quite clearly using civil liberties, human rights, and the Convention itself, as well as described as a wedge issue, to inflame and infuse the right wing of the Tory party instead of giving the moral leadership which all parties have taken pride in since its inception?
My Lords, I would not respectfully accept the characterisation put forward by my noble lordship. The approach in this bill is a balanced approach, as I have just explained, and is described in this morning's Times as a sound and constructive approach, a phrase that I would readily adopt. I fully accept that the great tradition of this country by the great lawyers such as David Maxwell Fyfe should continue and does continue. The UK is one of the most active members of the Council of Europe. We've not only promoted the Brighton Declaration, which I referred to a moment ago, which finally came into force last October. We've recently been party to a further recommendation on better dissemination of human rights information across the Council of Europe, to a declaration to revitalise Articles 5 and 6 on liberty and the right for a fair trial in particular. We've taken a lead in dealing with the situation as regards Russia and generally improving the mechanics of the court. And that leading role, my Lords, will continue.
My Lords, I'd like to welcome the Noble Lord to the dispatch box as well. When the Human Rights Act was incorporated into ECHR in 1998, I was a delegate to the Council of Europe, and I well remember many speeches in this chamber and in the Strasbourg Assembly about the importance of that incorporation process. And many of the speeches were directed to our new Eastern European friends about the importance of the ECHR. My noble friend's question is about the impact of this proposed legislation in Europe. Does the noble lord believe that the Bill of Rights introduced yesterday will enhance or detract from compliance with the Convention in Europe?
My Lords, thank you, my Lord, for your welcome. The government believes that when we have cleared away the fog surrounding this bill and fully understood it and together analysed it in detail, it will be seen to be a reinforcement of human rights, and it will not detract from the framework of human rights, and it will not have any adverse effect on our friends and allies in Eastern Europe and other members of the Council of Europe.
My Lords, it's a convention right that one should have a vote for the legislature that makes one's laws. Can my noble friend say whether he considers that that right is being vindicated in Northern Ireland at the moment, which is subject to laws made by a foreign power with no democratic say? Or is democracy simply a matter of a margin of appreciation?
Lords, that question, I anticipate, is somewhat outside the ambit of this present debate. I can add that in relation to Northern Ireland, the government is satisfied that this bill complies with the Good Friday Agreement and the withdrawal agreement and other relevant enactments affecting Northern Ireland. I think that's as far as I can